Assalamualaikum warahmatullahi taala wabarakatuh. My name is Nurmiza Patricia binti Hamad, and this is my presentation for my case review assignment under the subjects of law of contracts 2. So this presentation is prepared for my lecturer, Dr. Susie. Before we begin, I have to tell you that this video of me talking will have to be hid because it will disturb some of the wordings or pictures or whatever I have on my slides, and so you will not be able to see the words or the pictures clearly. So that is why I have to hid it. But no worries, it will still be me who's do the talking. So let's begin. The case that I'll be reviewing is the case of Fu Lianxin and another and Ng Chunlin and another in the year of 2006. And among others, we will be discussing on the case scenario, and we'll move on to the arguments of parties, significance of the case, ratio decidendi, and ultimately the conclusion. So let's go to the case scenario. The parties who would be involving in this case were Fu Lianxin and another and Ng Chunlin and another. So from this picture, as you can see, the plaintiff were the tenants of the shop house number 9. The defendant, on the other hand, owned the shop house number 7, which adjoined to the shop number 9. At the same time, the defendant is also the tenant for the shop of number 11. So the owner of the shop, both shops of number 9 and number 11, was this Mr. Yi. And according to Mr. Yi, the first defendant approached him, offering to buy over shop house number 11, of which he was the tenant at that time, and also the adjoining shop of number 9, which was occupied by the plaintiff. So then Mr. Yi said that he was willing to sell shop house number 11 to the first defendant. But in respect of the shop house number 9, he would have to offer it to the second plaintiffs first. He would only sell the shop house number 9 to the first defendant if the second plaintiff refused his offer. So the second plaintiff turned out to wanting to purchase the shop house number 9. And so Mr. Lee then took both second plaintiff and the first defendant to see the solicitor. He then told the solicitor that the shop house number 9 was to be sold to the second plaintiff, and for the shop house number 11 to the first defendant. He gave the solicitor a photocopy of a title of deeds on the respective lot of fish he had earned, marking by number 9 on the copy of title of deeds to be 6793 and shop house number 11 to be on the title of deeds of the number 6792. The correct marking should have been by reverse. The correct marking should have been the reverse. Number 9 should be 6792 and number 11 should be 6793. Unfortunately, the lands were subsequently conveyed to the plaintiffs and the defendant in the manner as they appeared in the respective SPA, with the plaintiffs becoming the registered proprietor of the unit 6793 and the defendants for the unit 6792. The High Court before held that it was in favor for the plaintiff. However, after the defendant appealed to the Court of Appeal, the Court of Appeal held that it was not a mutual mistake between the defendant. So in order for us to understand why the Court of Appeal held this way, we'll have to see the arguments of the parties. So let's go for the argument. As for the plaintiff, one of the arguments that they brought was it was a mutual mistake, and also they kept on repeating on the part of the wrong marked numbers on the title of deeds. But as for the defendant, however, denied that there was any mistakes in the conveyance to him on shop house number 9, because even the agreement was on his favor. And also the one of the arguments that he arose was the issue of privity of contract between those parties and the plaintiff. Also, it was said that the rectification, they argued, of the rectification of the register of the document of title can only be made in respect of mistakes common between two contracting parties. However, in this case, the defendant had nothing to do, and he was okay with whatever that he has gotten. So that's why we have to go see the ratio decidendi of the case, and it was stated by it was explained by the Court of Appeal that the ratio decidendi, or the reason behind their decision, was that the shop house number clearly could not prevail over the suratan hak milik sementara, and the PT number in all the documents, shop house number, was a number given by the local authority for the purpose of assessment. Furthermore, the shop house was part of the land. It could not be sold without the land. So it was the land that was sold with the shop house standing on it. So if the plaintiff might have been mistaken into thinking that they were purchasing the shop house number 9 instead of the land, if that was the case, then that was theirs. That was what was said by the Court of Appeal. So let's go to the significance of the case that I have managed to find. There are 4 significance of the case that I managed to get. The first one is comprehension, identification, essentiality, as well as mutual mistakes. So let's go one by one. The significance of the case consists, like I've mentioned just now, and we'll go first to the comprehension. As for the comprehension of the subject matter, this case has shown that it is crucial to fully comprehend the terms or figures in the agreement in order to bring it before the court, as it turned out that the mistakes of the agreement did not give a big impact on the parties' ownership, for the reason that the number of lots matters more highly as compared to the address number of the shop house, which had only been mentioned once. The parties and their solicitors have depicted to us that any subject matter of the agreement, which especially including a state property, are required to be fully identified correctly. This has also shown that the comprehension of the case is not something to be disregarded, for it is also one of the matters to help the aggrieved side to win the case. Lack of comprehension of the subject matter of the agreement
will only lead to a wobbly case to bring for the identification of the subject matter and more. Yet, without this case, we would not be able to see how parties of an agreement can misinterpret or misunderstand the agreement they are involved in. That is also one of the significance of this case has shown us. Besides the comprehension of the subject matter, the flow is also related to the essential part of the agreement that we need to scrutinize in order to present it before the court. Okay, so for the case that we are reviewing, it is with the assistance of the case of Sheikh Bros Limited and Auctioneer, which the Privy Council has stated the mistakes of facts had made it easy for this case to state where it mistakes lies. Even so, it helps side by side with the principle that the case Privy Council was established, as this case has shown strongly that it is important to have the facts of the agreement correct, which amongst all involve its identity. In the case of Fu Lianxin and another, and Ng Chunlin in another's case, arose when one party intended to deal with one thing which somehow turned out not to be as his favor. Therefore, it can be seen that the details or the terms of the agreement are way important than what was in the minds of persons. The mistake which is in the person's mind is not an operative mistake. What is operative mistake? An operative mistake means that a mistake in a contract that is serious enough to prevent the contract from being considered legal. That is in the absence for this case. To strengthen my point, according to Section 23, it was stated that upon the contract caused by mistake, as one party as to the matter of fact. It explains further that a contract is not voidable merely because it was caused by one party's to it being under a mistake as the matter of the fact. With that, the case has brought in the significance of carefully drafting and doing a final checking before the contract is made legal. This is because not all mistakes in contract can be considered void in the name of mistakes. If this case is left disregarded, it is not impossible for the same scenario to repeat itself in the future because of the idea that a contract which contains mistake can be easily amended. So by identity of the subject matter here, it is an eye-opening for me as a law student to compare the case of Flax and Williams, which is categorized under the mistakes as to the identity of the subject matter. It was in that case, it was due to the vague statement in the telegram that the court had declared that there was no contract for the parties, as the mistakes was clear. In contrast, the mistake in the case of Fu Lianxin and another and Ng Chunlin and another was in the minds of the plaintiffs, but it was written correctly in agreement. After all, no vague statement contained. The parties in this case had realized that the address number of the shophouse had been wrongly stated, as it got twisted between the oral and the written order of the previous shophouse owner. It has depicted to us that identification of the subject matter in the agreement is highly important, as it is related equally to our composition of the agreement, which also falls under the essentiality of the agreement as provided under the case of Sheikh Bros Limited and Auctioneer. Without a sufficient and thorough understanding of the agreement, possibilities of getting the identity of the subject matter wrong is similarly high. Another thing is, it is also important to know that the very main issue or subject matter of the agreement, instead of his position, another thing is, it is also important to know the very main issue or subject matter of the agreement. For example, in this case, the parties only focused on the number of house address instead of his future possible ownership of the lands. With that, it made the parties more confused, as they were not ready for that matter. They did not see that the problem they were in was way bigger than what they had expected. This would not happen if the parties realized that the agreement they agreed on was upon something bigger than a shop house. In the Scriven Brother and Company and Hindley and Company, it was regarding a bidding of lots, which was named after SL Works, and it was between two kinds of lots that they were under the same name, but one was having a cheaper value than the other. So with that, it was not the identity of the subject was vague, and so that was why the court held the agreement was void. But it was not in this case as for the Fu Lianxin and Ng Chunlin. Moving on to the next, the ultimate point is that this case is of importance to show to us that the main requirement to apply for the court under the mistakes of an agreement is that it shall not be mutually committed mistakes only. In relation to the case of Ho Wang On and Bin Defsun Berhad, the court rejected the defendant's argument when the defendant claimed that both parties had been mistaken for the availability of the double-story semi-detached house that was the subject matter of the agreement. However, in this case, the defendant denied that he had any problems with the shop house he had purchased. It also showed that he was fine with what he had gotten. The case had laid before our eyes the importance of studying the arguments to bring before the court deeper. This is there is a unilateral mistake to claim, even though it was not that they would win the case anyway, but since that what was written in the grant shall prevail due to the absence of the operative mistakes, well, at least they could have get their main arguments stronger after making their arguments suitable to their situation. For the conclusion, it can be said that there were so many significance from this case that we can learn upon how the the skeleton of this case was not very strong, being presented by the plaintiff side, and also the defendant was also, due to the arguments of the plaintiffs of being wobbly, so the counter argument of the defendant also were not actually in the line with what the Court of Appeal said. But eventually the defendant won and he got whatever he had wanted to maintain. But as we can learn from this, there are more to cases. Even if we read it for just 5 to 6 times, there were still something that we need to explore more, because there might not be just one issue of the case, and it might be not just one chapter related to it. There might be more and more acts should be related to the facts of the case that we have to study in order for us to bring it before the court. So with that, I hope you understand my presentation, and thank you so much for listening. Assalamualaikum warahmatullahi taala wabarakatuh.